April and March, the ABA called on the Executive Office for Immigration Review in the Immigration Customs Enforcement to take steps to further protect the health and safety of individuals working in and appearing in our immigration courts that remain open during the pandemic. We believe that additional uniform measures are needed to ensure the protection of individuals while preserving non-citizens' access to legal representation and information, as some non-detained hearings and others continue to resume. The ABA also called upon EOIR to withdraw a proposed rule that would increase existing fees dramatically and for the first time include a fee for filing a defensive asylum application. The U.S. Citizenship and Immigration Services and EOIR proposed rules increasing fees. Those rules have not gone into effect, but have been forwarded to the Office of Management and Budget for final review. So that decision should be forthcoming in the next several days. We also encourage EOIR to temporarily suspend all immigration court hearings and appearances for unaccompanied children held in the Office of Refugee Resettlement custody. The hearing for unaccompanied minors in ORR custody has not been suspended and have proceeded throughout this pandemic, although some judges have canceled these dockets while others' dockets have continued. The ABA expressed concern to the Department of Homeland Security on the failure to initiate removal proceedings for unaccompanied children previously subject to the migrant protection protocols. MPP hearings are currently suspended until next month. MPP affected unaccompanied children are being deported on prior MPP orders as we speak. Yesterday, there was a DC Circuit decision regarding the administration's proposal to expand expedited removal to anywhere in the US for people who cannot prove that they have been in the US for at least 2 years. The ABA opposed the proposed expansion and expedited removal. ABA policy on asylum opposes legislation that would not provide for appeal to an independent administrative body for all persons subject to administrative orders of exclusion or deportation or to denial of asylum claims. That's a quick snapshot of the work that we have been doing in our ongoing efforts in the immigration arena. I want to thank all the extraordinarily talented, knowledgeable, and experienced speakers that have joined us for this program, and thank all of you participants for all you are doing to make a difference for those who need us so much at this time. We know this panel will make an extraordinary contribution to the dialogue that needs to go on through this second summit and beyond. Thank you, Carolyn, very, very much.
Thank you, President Martinez. We are so honored to have your support. Thank you so much for your support and your impressive remarks and supports to immigrants. As we've seen this week, everything is under attack. So thank you so much. So this program is Immigration in North America During COVID-19 is sponsored by the American Bar Association, Commission on Hispanic Legal Rights and Responsibilities, co-sponsored by the Section of Civil Rights and Social Justice. This panel is one of 3 meetings that the Commission Legal Summit of the Americas 2.0. There will be 2 other seminars, one on the environment, other on business, that will be held later in the summer. For more information, please visit the webpage of the Hispanic Commission, and a link will be posted in the chat box. So the world has become a world that we never imagined. If we were experiencing the storyline plot of a sci-fi movie, we would never believe the plot. Such is the time of the coronavirus. And what a seismic week, and it's still coming in the US with the US Supreme Court decision on DACA, more visa restrictions and bans, and today the United States Supreme Court sided with the Trump administration on a case concerning asylum. The American Bar Association is so proud to present this very timely webinar. We are honored to have an esteemed panel, international panel of speakers from all over, from Mexico, from Canada, and the US. They will share their perspectives of the impact of COVID-19 on immigration in all 3 countries and what possible developments that immigration practitioners can expect in the future. We have a very impressive panel, and I'd like to introduce them. So I'd like to introduce Ravi Jain, who is the national chair of the Canadian Bar Association National Immigration Law Section. He is also a managing senior lawyer at Green and Spiegel LLP in Toronto, operating under his own professional corporation. Called to the bar in both the United States, he has over 19 years of experience and is a small percentage of people certified by the Law Society of Ontario as specialists in immigration law. He's been invited to address committees in both the Canadian Senate and House of Commons as a subject matter expert in immigration law. He was presented with the Diamond Jubilee Medal by command of Her Majesty the Queen in recognition of his significant contributions to Canada. He has also been selected for a leading immigration lawyer by Who's Legal, the Canadian Expert Directory, Chambers and Partners, and Best Lawyers in Canada. He's a graduate from Queen's University with a BA. He attained his LLB from Osgood Law School and his LLM from the University of Michigan, and he's the author of various books. So we want to welcome Ravi. Our second panelist is Elba Gutierrez. Elba is a Mexican lawyer who is a full-time pro bono attorney. She coordinates the pro bono program at Greenberg Traurig Mexican office and focuses her practice on matters concerning civil and social rights. She advises and represents through strategic litigation clients whose rights have been violated either by particulars or directly by the Mexican state. Elba has focused on the right to seek asylum in Mexican community and its implications at the regional level. The pro bono work done by Greenberg Traurig in Mexico has been broadly recognized for its positive impact on society. Welcome, Elba. Maria Elena Abraham is counsel from Mexico with more than 25 years of experience in immigration procedures, such as the obtainment of temporary resident status, obtaining of permanent resident status, renewal of immigration documents, replacement of immigration documents, procurement of special permit letters to travel abroad, and notifications. She has involved in the exchange of immigration from the I think Mexican equivalent of lawful permanent resident to immigration card, registration of Mexican companies, updating. She provides advice and assistance to obtain consular visas to enter Mexico and obtain business visas to enter Mexico. She gives assistance to consular visas to travel to other countries. Welcome and thank you, Maria Elena.
Thank you.
So César Cuauhtémoc García Hernández is an associate professor at the University of Denver's Sturm College of Law and a frequent commentator in national and international media. He publishes Crimmigration.com, a blog among the convergence of criminal and immigration law that is at the past recipient of 100 best law blogs honored by the ABA Journal. César's academic interests also center on crimmigration law. His articles about the right to counsel for immigrants in the criminal justice system, immigration imprisonment, and race-based immigration policing have appeared in the California Law Review, UCLA Law Review, Brigham Young Law Review, Maryland Law Review, Georgetown Law Journal, among others. And he's written a book, Crimmigration Law, which was published by the American Bar Association in 2015 and is working on a second one. So we want to welcome César. Thank you. Our last panelist is from here in Chicago, where everyone is located, is Guadalupe Perez, who is a supervising attorney with the National Immigration Justice Center. She represents individuals in detained removal proceedings before the Chicago Immigration Court and the Board of Immigration Appeals. She also supports the Legal Orientation Program, which is located in McHenry County, and until recently, the Kenosha County Detention Center. The National Immigration Justice Center has several projects, but specifically the Detention Project works with individuals detained by ICE, Illinois, Wisconsin, and Kentucky. These individuals can be arriving asylum seekers or individuals that have been living in the US. Lupe also serves as the chair of the American Immigration Lawyers Association chapter for legal services detained individuals. She is a graduate of DePaul University College of Law, licensed in Illinois, and prior to going to law school, Lupe was a Peace Corps volunteer. Welcome, Lupe. So that is our panel, very esteemed panel. Ravi, if you could please begin the presentations. Thank you all, and thank you for everyone for coming in.
Thank you very much, Carolyn. That's wonderful. Okay, so I will get going. I'm just going to share my screen now. There we go. And I'm just going to swap. Okay, so this is the agenda. I'm just going to talk very quickly about what the latest information is with respect to Canada, an update from the Minister of Immigration on some items, and then talk about the Canadian travel ban and how it relates to families and workers coming in. And also a little bit about the quarantine now. So I'll jump right in because we have a very short amount of time. So I did do a Minister of Immigration sort of Q&A. The Minister's office kindly reached out to me. So I did actually two of them, one for our national conference and one where we just chatted about when the pandemic started. And he did give a few different interesting updates. First, he talked about the levels plan. And so for Canada, the government sets a levels plan in terms of the numbers of immigrants they want to bring in every year. And the current government had set a 3-year level plan. And so the big question I had for him was, are we going to hit target? And he said he was committed to immigration. He said, I pointed out to him that in the last recession, the previous government had maintained immigration levels during the recession and then right afterwards, and that was a conservative government. This government is a liberal government, and I asked him if he would do the same. The difference is that it's not just a recession, and as he later clarified in the House of Commons, it's not that he doesn't want to maintain the levels of immigration. He understands that it's good for the country. There's been recent reports that related to, for instance, the Spanish flu and how the number of babies being born declined. We're going to expect something similar. That's going to be an even greater challenge because you have the pandemic, that's affecting the ability to bring in skilled workers. And then you have the already low birth rate being even worse. And so the commitment from the minister was that he was going to do everything he could to maintain the levels, but the reality is that operationally they're having difficulty doing that. There's also a program in Canada of being able to sponsor parents and grandparents. This is a very popular program. As you can see, it's delayed. Probably doesn't make a lot of sense to bring in elderly people into Canada right now, but the government indicated they're committed to it and they'll revisit it as time goes on. In terms of students, this has become it's been a huge increase in the number of international students. I think a 74% increase since 2014. So massive numbers. All Canadian institutions who bring in international students have come to really rely on the very high foreign tuition fees that they pay. And it's really been assisting, some smaller colleges in various parts of the country really ramp up and, with their infrastructure, et cetera. So the innovation is that we're allowing them to be up to 50% of the time outside of Canada or online and still be eligible for the coveted work permit that you get after studying in Canada that puts you on a pathway potentially to immigration. And you can work full time if you're in a critical, providing critical services. So another little give that they gave. Also, we can become permanent resident by email. So before you had to officially get your Canadian green card, if you will, or your Canadian permanent residence, by attending an interview. Now they'll just email you and boom, you're a permanent resident of Canada. So there's also a new innovation where before you had to, if you had a new employer that wanted to hire you, you had to wait a long time to get your work permit up to 89 days. Now, with certain criteria, you're able to get authority to work even before getting your work permit. So that's an innovation. They didn't want people sitting on their hands if they had new job offers. Now, getting into the travel ban, there's two of them. The way it's structured in Canada is there's a travel ban related to the United States, and there's a travel ban related to the rest of the world. So we'll talk about the US one first. It's by way of order in council. So cabinet makes the decisions here pursuant to the Quarantine Act. So generally, if if you're not coming for an optional or discretionary purpose, then you can come in. So what's optional and discretionary? Well, tourism, recreation, etc. So if you say I want to go, visit my cottage or my lake house, if you want to go visit friends, etc., it's not the time, is what they say. Now this does not apply, and there's been a lot of advocacy I've been doing, and a few others as well, because there were horrific stories of people trying to come into Canada and witness the birth of their child, or they wanted to come in and join their spouse, and they were being denied. And we'd never seen that kind of treatment to Americans before. So now, after a lot of advocacy, they've clarified that if you can show that you're coming for longer than 15 days and you want to be with an immediate family member, and there's a broad definition of that, then you're able to come in. Of course, you can't have COVID symptoms, and you've got to be able to quarantine. So with respect to the travel ban for all other countries, for workers, you've got to have a valid work permit or a work permit approval. Your dependents have to, either have, like if your spouse or common law partner has to have a study permit or a work permit in their own right. The kids, if they have if they're coming in visitor status, they now need special permission, a special consular letter. So very old school with a little stamp on it sometimes, or official email. That's the way it is. For others, for students, they have to be approved before March 18th. If you're a COPR holder, meaning you have a confirmation of permanent residence, so you're about to become a permanent resident of Canada, again, before March 18, then you can come. Or if it's in the national interest, you can come, and any of the three ministers listed can approve you. Now, there are exceptions. So, of course, if you're providing medical emergency or other essential services, you can come as long as you don't have symptoms. If you, again, if the purpose is optional or discretionary, you can't come unless you meet the exception. Now, there is also, according to the latest order in council with respect to other countries, there's a new exception, again, very similar to the one for those coming from the US, not Americans, but just anyone coming from the US, in that if you're, again, reuniting with a Canadian or permanent resident and you can show you want to stay for over 15 days, you're able to come once again. So for foreign workers, the question is, are foreign workers able to enter, yes or no? And the answer is, if you're coming from the US, yes, which may seem a bit odd to people because, of course, the pandemic is sort of raging in parts of the US, but the way this was envisioned, it's our largest trading partner, longest undefended border in the world. So we have special relationship with the US. You can come in and present and apply for your work permit if you're coming from the US. If you're coming from another part of the world, you have to have your work permit approval beforehand. And so you can't just show up and apply for a work permit. There's a bit of a blurb here on reuniting. If you have a work permit and you want to bring in your family members, technically you have to come first and then your family members later. But in practical reality is that although it's on the books and you can see it in the order in council, that's not our experience. We're getting people approved all at once and people are coming all at once. Now, this rule about having to have a work permit approval or an actual work permit before you can come that applies to the rest of the world, that all relates, it's all by authority of a ministerial instruction. So in Canada, the minister can issue an instruction and boom, that's the law. So very different from the US, where there's a lot of bipartisan, well, a lot of sort of gridlock and inability to make rapid change in immigration law. With our political system being a little different, we can make these kinds of rapid changes. And finally, with respect to the Quarantine Act, you just have to show that you're going to quarantine for 14 days when you're coming into Canada. You have to have a mask. You have to have a location you've specified. You have to show how you're going to reach that destination, how you're going to get groceries and other necessities. And, you have to show that you're going to separate from vulnerable people. So older people, people who are compromised in terms of their immune system or have a medical condition, etc. So that's my presentation, immigration in a nutshell in terms of Canada in this era of COVID. And I'm looking forward to answering questions and participating in any discussion. Thank you.
Thank you. That is wonderful. And just an aside, when we open up the platform for questions, please use the Q&A icon at the bottom of your screen. And when you do ask a question, if you could mention is the question to Ravi from Canada, to Elba or Maria Elena from Mexico, or to César and to Elba from, Lupe from the United States. So if you could do that. So thank you very much for a very, very informative, very interesting situation in Canada. Guadalupe, would you please take the floor? You're muted, and
bear with me while I work through this technology and share also my screen. Okay, so I'm going to talk. My name is Lupe. I work for the National Immigrant Justice Center, and I'm going to focus on the immigration courts and how they have responded to the COVID-19 pandemic. So for a little bit of background, the immigration courts in the United States are federal courts, and they do divide their dockets between the detained docket and the non-detained docket. The detained docket is primarily for individuals who remain under ICE custody while their proceedings continue, while the non-detained docket is for everyone else who is in removal proceedings while they are facing, while their case has been decided as to whether they're going to stay in the United States or not. So the response by the Executive Office of Immigration Review was a little bit haphazard as the pandemic started, and it continues to be slightly chaotic with different dates of when courts are opening, when courts are going to close for a day or two. So in general, the non-detained court canceled hearings from March 18, 2020 until various points. Right now, the Chicago Immigration Court is slated to open July 6, 2020, but each immigration court has decided its own date of opening. The National Immigration Justice Center and AILA, the American Immigration Lawyers Association, has called for a non-detained court to remain closed. And that's partly because the pandemic still continues. And the way that non-detained dockets work is that there can be hundreds of people in this enclosed spaces. And also when people have master calendar hearings, multiple people are being packed into enclosed spaces. So that really raises the risk for people being exposed to COVID-19 and is contradictory to the CDC recommendations. Also, what we've been seeing is that as courts open and individuals come in, there can be COVID-19 scares or concerns, and then the court suddenly closes the next day or closes for a couple of days. And that just leads to unpredictability. And individuals don't know when they're going to show up to courts. They don't know if court's going to be open. As practitioners, you don't know if you're going to be proceeding on a hearing or not. So in order for things to remain uniform and in order for individuals to be safe and for court personnel to be safe, we are encouraging EOIR to maintain the closure of the non-detained courts. We're also hoping the non-detained courts take the stand that they won't order deportations in absentia. So what happens when an individual does not show up to their immigration court hearing, the immigration judge will order them removed in absentia without taking into consideration whether they are sick with COVID-19 or if anything else is happening, if public transportation can still happen. A lot of these immigration courts cover large geographic areas. For example, the Chicago Immigration Court covers Wisconsin, Indiana, and Illinois. So all of these three different states have different ways that they're handling the pandemic and different reliability on transportation that would make it difficult for people to show up to their court dates. So because of that, we're also asking EOIR to not order people removed in absentia. Meanwhile, the detained court has been a whole different scenario. So detained court has continued, and that's primarily because it's a fine balance between making sure that everyone's safety is in consideration, but also ensuring that people's cases move forward, and so that we can advocate for individuals to be released on bond or paying a monetary amount so that they are no longer detained. What has happened though is that, well, a lot of these courts are also located inside detention centers or jails. So at the beginning of the pandemic, ICE and jail centers were asking practitioners to come into court wearing personal protective equipment, which if everyone remembers 2 months ago, it was incredibly difficult to obtain PPE equipment and also incredibly difficult for practitioners to enter the courts and proceed with their clients' cases with this equipment. So now the courts have moved on to telephonic hearings for the most part, which is difficult because a lot of what happens in court, if someone is applying for discretionary relief, a client's demeanor is really important. And if you don't have them face to face and you're just going by what you see via video teleconference, that can be problematic as well, but also balancing that we do need to get people outside of detention, especially as ICE continues to detain individuals interiorly. The border is a whole different area, but interiorly, they are still continuing to detain people. And they're also holding the position that they will not release people because of COVID-19 concerns. So just to briefly mention, I know someone else mentioned the migrant protection protocols. Those hearings were also canceled, and that's problematic as well because you have individuals that are in very precarious situations along the border. For the most part, what practitioners are doing in order to get clients released, besides getting bond from immigration courts or asking various ICE field offices to get their clients released, is that they're moving towards something called a habeas or filing for a habeas in federal court. And that has had more success depending on the district where the field office or where the person is detained. So with regards to family-based petitions, so these ones are mostly adjudicated by the United States Citizenship and Immigration Services, and they canceled all of their in-person services. So that basically means that anyone who's waiting to get an interview, for example, if your spouse is applying for you to get residency, those interviews are not happening. So those proceedings are suspended for the time being. Also, asylum office interviews are being suspended. So that means that people who have been waiting for a long time for those asylum interviews will face longer delays in their proceedings as well. And now I'm going to briefly discuss some immigration bans. The United States, this administration has been really keen on issuing immigration bans. It seems like they like to do one every month, but I'm just going to cover the ones that have happened during the pandemic and that they have used the pandemic as an excuse for their immigration policies. So the first one happened on March 20th, 2020, when the Trump administration essentially sealed the United States border. This was a violation of international law because that means that anyone who wants to seek asylum is no longer able to do so at this moment. We are hearing reports of individuals who are being deported without being asked if they have a fear of return, without being asked about any trafficking concerns. This goes both for asylum seekers and also for unaccompanied minors as they attempt to enter the United States. And then the April 22nd, 2020 ban was essentially to freeze family reunification from abroad. And there's a lot of litigation going on with these bans. So anything can happen or different interpretations could happen in the next couple of weeks. There just was a case where Gomez versus Trump, where one of the aspects of this ban was that if a child aged out, then they would face longer delays with the adjudication of their application. But now they're essentially freezing the children's age so that they can continue with the family reunification process. And then the latest one, which just was released this week, essentially extended the freeze from the April 22nd ban. And it's also being seen as the most extensive ban that we have seen towards work visas, where previously the administration hadn't been touching employment visas. But I believe someone else will discuss a little bit more about that. And that's our contact information. Thank you, everyone. Look forward to answering your questions.
Thank you so much. Greatly appreciate everyone participating, and should give a big shout out to the Canada Bar Association, who is co-sponsoring this session with us today. So we're very, very grateful in doing that. So if our next speaker could please be Elba Gutierrez, who is a Mexican lawyer. Elba.
Sorry, I was muted. Sorry. So we are going to speak about the Mexican landscape on asylum seekers and immigration issues. I'm going to be presenting the asylum part, and María Elena will be completing with the immigration part. So I'm going to share with you my screen now. Okay, so first of all, I would like to be very clear that in Mexico, the asylum procedure is handled by COMAR, which is the Refugees Commission in Mexico. And this is a very different entity from the Immigration Institute. Before COMAR, you will have an administrative procedure, which is kind of scheme in these roles. And basically you will have 5 stages. So once you get into Mexico, you will have to apply because you have to be here in Mexico in order to request for asylum. And then you will get a constancia, which is a paper saying that you're an asylum seeker. Afterwards, you will have to fulfill a questionnaire with basic information, why you are running out of your country, whether you have a family or not. And then you will have an interview. Some people say that the interview is the most important part of the procedure because, of course, this is the face-to-face hearing, before an officer from the Mexican state who's going to ask you why you are here or why you cannot go back to your country. So the whole procedure will end, of course, in a resolution, which can be, it can be positive and saying that, okay, you are a recognized refugee or an individual with international protection, or it will be negative. If it is negative, then you will get the chance, to appeal this ruling. And, there will be 3 options, mainly for practitioners to decide with their clients what they want to do. So this is very important for you to know, because this is not a judicial procedure. This is an administrative procedure, and according to the law, the time frame is very specific. So the whole thing can last up to 45 days. That can be extended for the same amount. So it will be 90 days. And in any case, the authority will have 10 days to notify you the resolution. So, in theory, and according to the law here in Mexico, an individual requesting for asylum will have to go through a procedure of 100 days in the worst case scenario in order to get the resolution. So it's very clear, it's very secure. You have a very, clear time frame in which you're going to be working, and over which you will get a humanitarian visa from the Immigration Institute. But the thing is that is the theory. In practice, it's quite different. We can start talking from 2017. So in 2017, we have a major earthquake here in Mexico, which led us to the first suspension that we have in the recent years. So COMAR has offices in some places, not in the whole Republic, but one of the most important, of course, is the Mexico City office. So we have this earthquake, and the offices of COMAR were damaged. So they issued this suspension of terms saying, okay, we are gonna keep receiving the asylum request, but we are not gonna do the interviews. So this stage of the interviews as the issue of resolution will be canceled. So it was very confusing because over the time, what the authority did was lifting the suspension for certain people. But the truth is that if you request for asylum, you will be subject of the suspension at the end of the day, and it will mean that your procedure will not be really secure because then you won't have a certainty of the 100 days, but some people have been waiting until 1.5 years or even more. So we had that suspension in place, but now in the 2020, because of the COVID, on March 24th, what the authority decided was to put a suspension at national level. So it meant that it was not applying only for Mexico City, but in general for the whole country and all the offices in Comar. On April 23rd, we had the first extension saying that the suspension will be in effect until May 3rd. And then on May 27th, we have a suspension declaring this as an indefinite phenomenon because it will last until the end of the sanitary crisis. So basically, Comar said, okay, we are going to keep working on accepting the request, but we are not going to be holding the interviews or issuing resolutions. Something very important to say is that offices have been open all this time, that they have been accepting this request with some issues sometimes, but more like bureaucratical issues, and that the non-refoulement principle is being preserved. So what the authority says, okay, we're not going to be working the whole procedure out, but we will be protecting people from being deported or being, sent back to wherever they are coming because their life is at risk. Other important thing to say is that Comar issued a special protocol in order to attend the people who is asking asylum right now. And even though the interviews are suspended, they have been holding some telephone hearings and some resolutions have been issued. Another important thing is that vulnerable people, vulnerable individuals asking for asylum have also been placed in this priority scheme in order to be, attended, and that the children are also a subject of priority. However, the thing is that the asylum system here in Mexico has been, overflowed with all the requests that we have been holding for the last 5 years on this. So we have been having these raisings in requests. As you can see, from January to May, this is the comparative, and these are official numbers from the Comar. We have been having about 5,000 requests for the 3 first months, and then we have a dramatic drop to almost 1,000 in April and almost 1,000 in May. So these are the asylum numbers, but what has been happening too is that we have two kinds of asylum seekers. We have those in freedom asking for the asylum, and we have also the people who has been detained in the immigration centers handled by the by the National Immigration Authority. So the landscape in there is that immigration issued also a special protocol on, how to keep social distance and stuff for people who have been detained. But also the thing is that the detention center have been overflowed for many years. So some colleagues from really brave NGOs filed an amparo, which is a constitutional trial, in order for the Immigration Institute to start to keep these measures actually enforced. The result is still pending on that trial. I know that the colleagues have been working hard on that. The thing is also that at the end of the day, they also got that the Immigration Institute issued this kind of protocols. But the truth for the asylum seekers is that there are so many bureaucratic barriers at the end of the day in order to ask for asylum. So if you are detained, you are not facing only the fact that you are, deprived from your liberty, but you are also waiting for someone from Comar to come to the immigration center in order to hear that you want to seek for asylum. And once you are seeking for asylum, then you will have to face this uncertainty in the procedure, because then you won't have a specific date or at least a time frame in order to know how long to wait for your procedure. And even if you get your procedure going, you might get into these pipelines of cases to be worked. by the authority. So of course there have been a specific, consequences on people asking for asylum here in Mexico, because there is this, the dramatic dropout of people asking for asylum from the 3 months to now is not only about COVID-19, it's about the bureaucratic barriers that they are facing, and also the thing that, once getting maybe to the northern border, they might be asked to request asylum here first in Mexico, and then having the possibility to ask for asylum in the United States. So the biggest challenge here, of course, is the uncertainty that people has been handling. Some practitioners have been trying to get amparos, which is this constitutional trial, in order for people to get their right to seek asylum protected and in order for the procedures to keep moving forward. But the truth is, and again, I want to be really, really emphatic on this, is that the system is quite overflowed. So I will handle the word to María Elena, who will keep talking about this, about the immigration part in the Mexican side. I'm looking for your questions.
Thank you so much, Maria Elena.
Thank you. Thank you so much, Caroline and Elva. Thank you, everybody. Thank you, everyone, for being here. Good morning to everybody. So before I share with you how COVID-19 has impacted our immigration procedures, I want to give you a general overview, and I promise this won't take more than 3 to 4 minutes. I would like to share with you a general overview about our immigration law and the 3 main categories that we have under which foreigners may remain in national territory. So the first one is visitors. The second one will be for those as a temporary residents. And the third one will be for permanent residents. So as you can see, we have a very friendly immigration law with only 3 main divisions. So let's go real quick to the visitors. So this legal status is granted to foreigners in transit or entering the country without the intention of establishing a residence in the country. So this status is one of the most commonly used for foreigners entering Mexico. And this status is divided in 6 subcategories. So the first one will be for those visitors with no permit to engage in paid activities. So here we have those coming to Mexico as a tourists, or those coming to Mexico, for example, as a business visitors. So US citizens and Canadian citizens may just take a plane, and during the flight, they will be given an FMM, a multi-purpose immigration form, that will be validated to stay in Mexico for up to 180 days. So in this particular case, and talking about Mexico, Canada, and the United States, you know that Canadian citizens and Mexican citizens won't need, prior to their entry into Mexico, they won't need a consular visa. Let's move on to the second category of visitors. That will be for visitors with permit to engage in paid activities. So let's say that Madonna is coming to give a concert, and she's going to be paid directly by the Mexican entity for that performance. So this will be the kind of visa she will need to have. Then let's move on, and let's talk about the regional visitor. This only applies for citizens of Guatemala and Belize, and this permit will grant 3 days for them to stay in Mexico. The border worker visitor, which is also for nationals of Belize and Guatemala. Then we have the visitor for humanitarian reasons. Elva was talking about that a little bit early. This visitor category for humanitarian reasons, it's granted under any of the following assumptions. Either you are a victim or a witness of a crime within Mexican national territory, or you are an accompanied boy, girl, or teenager, or you are a petitioner of asylum or a refugee. And finally, we have the visitor for adoption purposes. It's very common in Mexico that couples from the US and Canada come to Mexico and go to some southern states, for example, the state of Oaxaca and the state of Chiapas, in order to adopt. So the second category, which is the category because this is the most commonly used, it's the temporary resident. So the temporary resident status, it's given to those foreigners that will stay in Mexico for more than 180 days and less than 4 years. So since we handle corporate immigration, this is the most suitable category for them, for the assignee, for the spouses, for the children, and even for the nannies coming with the assignee to Mexico. And the second division, because under the temporary resident status, we have two divisions. So the first one is temporary resident, and the second one is a temporary resident student, which is granted to those foreigners wanting to come to Mexico to study. At this moment, most Mexican consulates are closed. So this process begins at the Mexican consulate. So for the moment, they will have to wait. And then we go to the third and final immigration statuses division, which is the permanent resident status, which will be granted to those foreigners wanting to stay in Mexico under a definitely basis. And this condition will be granted due to the right to preserve family unit. This is also granted for those retired individuals or pensioners coming to Mexico. And also we have a lot of US nationals and Canadian nationals coming to Mexico as a retired or pensioners, and they just love to live here. Because 4 years have elapsed as from the time you hold a temporary resident status, or because you have a Mexican child by birth, or for political asylum conditions, acknowledgement of refugee condition or supplementary protection. Let's talk about the National Immigration Institute. So the National Immigration Institute, it's the authority in charge of handling every immigration process in Mexico. So the National Immigration Institute, well, let me just go back a little bit. On April 1st, the Ministry of the Interior published in the Mexican official Gazette of the Federation a suspension of terms regarding deadlines and the expiration dates. So this suspension was directed only to temporary residents and to permanent residents. The suspension was extended first to May 30th, and again extended to June 1st, and now we currently don't have an ending date. So notwithstanding that we have a suspension of terms, the national immigration is still open and still receiving all kinds of processes. Of course, we have to take into consideration that they are working with less personnel, so they are accepting less processes every day. So you have to be there very early in the morning to catch a ticket so you can process and file your process. You also have to take into consideration that each local office of the National Immigration Institute, it's applying their own criteria in which documents can receive or no. Now, and this is of course new, the National Immigration Institute is issuing visitors visas for humanitarian reasons due to COVID-19. And this is because we have a lot of foreigners in Mexico right now that they cannot return to their home countries, and they have the visitor status expired, that they entered in November or in December or in January, and they cannot return to their home country. So for this reason, the National Immigration Institute, it's kind of extending the legal stay in favor of these foreigners, but the process is that they are issuing a visitor visas for humanitarian reasons due to COVID-19. But talking about the Ministry of Foreign Affairs, and this will refer to all Mexican consulates abroad. On March 26, also the Ministry of Foreign Affairs published a suspension of terms, and there is also no end. So most Mexican consulates at this time are closed. In the US, some of them are opening gradually, and also in Canada, just for you to know. Regarding the border within Mexico and the US, you know that both governments agreed to limit the access. So only essential travelers between Mexico and the US can enter. If you are flying from Mexico to the US, there's no problem. And the foreigners coming from the US to Mexico, there's also, we do not have any restriction or bans for them. But if you want to go to the United States by car or just crossing the border, then you will not be admitted if your purpose of your visit it's entering the United States as a tourist. If you work there, if you study, if you're a US citizen, if you are a lawful permanent resident, then you may enter the US. But if you are just going as a tourist, you are not going to be allowed to enter. And finally, to finish my presentation, let me tell you that we do not have Mexico as a country. We do not have any travel restrictions entering Mexico. There's no mandatory quarantine upon arrival in Mexico. So any visitor must fill out a COVID-19 related questionnaire, have their temperature taken, and well, of course, those entering Mexico presenting high fever or cough or breathing problems or breathing difficulties will not be allowed to enter Mexican national territory. So in general terms, we have no restrictions, and we have no bans entering Mexico. What we expect in terms of future, we seem that everything will continue the same, because as I mentioned to you before, notwithstanding we have a suspension of terms, the National Immigration Institute is working normally. So thank you very much. Thank you very much.
Thank you so much, Maria Elena. And César, if you could please provide your presentation.
Wonderful. Thanks so much, Caroline, and thank you for joining us this morning. I want to just briefly, before I get into some of the topics that I prepared to talk about, I want to briefly just note a Supreme Court decision that came out this morning, just a few hours ago. So I've only had the very briefest of opportunities to review it. But at bottom, the court in Department of Homeland Security versus Thurasigyam That is undoubtedly not the accurate way of pronouncing that name. But the court came to the conclusion that it further limited the role of the federal courts in reviewing what is the very first step of the asylum application process in the United States, and it repelled two constitutional challenges in a line that or in a conclusion that I think is worth reading just very briefly. In the majority opinion by Justice Alito says, aliens who arrive at ports of entry are treated for due process purposes as if stopped at the border, meaning that the statutes adopted by Congress and the president take precedence. So we'll obviously have more to hear about that case in the coming hours and days and weeks. But that's actually not the Supreme Court decision that I really wanted to start off my comments with. I actually wanted to turn to a case that was issued last week about deferred action for childhood arrivals, DACA, before turning to some of the litigation that's been going on in with regard to the prison system that the Immigration and Customs Enforcement Agency operates, as well as the presidential proclamation restricting issuance of non-immigrant visas that was rolled out just a few days ago. And to the extent that I have any time remaining after that, talk about some of the issues with regard to the Migrant Protection Protocol and other border closure efforts by the Trump administration in the last few months. But the DACA decision was one that was long in coming. This is the last days of the Supreme Court's term for this year, and so it was not at all surprised that this decision came out in these final weeks. And so last week in the Department of Homeland Security versus Regents of the University of California, the Supreme Court came to the conclusion that the Trump administration's efforts to rescind the DACA program violated federal law, specifically violated the Administrative Procedure Act, which bars governmental actions that are arbitrary and capricious. The court's conclusion was that the Trump administration's decision to rescind DACA was arbitrary and capricious because it failed to consider the fact that migrants had come to rely, several 100,000 migrants had come to rely on both the reprieve from removal that DACA provided, but also the employment authorization, the eligibility that DACA provided. And in addition to that, the court concluded that the rescission attempt was arbitrary and capricious because the Department of Homeland Security, which operates the DACA program, had failed to consider the possibility of a more limited rollback of DACA. Specifically, they had failed to consider the possibility of simply eliminating the employment authorization eligibility while maintaining the reprieve from removal aspect. And so we're back in somewhat of a step one or step zero, waiting to see what happens next. The Supreme Court did not at all weigh in on the legality of President Obama's decision to initiate DACA. And instead, this was focused squarely on the Trump administration's decision to roll back DACA. This does not mean that they cannot roll back DACA. It means that they need to start over with their justifications for eliminating DACA. And I think everyone fully expects that the administration is interested in doing that. And the question is whether or not they can do that. They can manage to roll out new justifications before before the presidential election in November or in January when President Trump's term ends. Of course, all of which is contingent on the results of the November election. In the meantime, the Department of Homeland Security's U.S. Citizenship and Immigration Services Agency, USCIS, which is responsible for adjudicating DACA applications, has not announced what it's doing, whether it's accepting new applications, whether it's only accepting renewal applications. The expectation is that they will accept new applications as well as renewals, but we haven't yet seen anything more than an announcement of enormous displeasure with the Supreme Court's decision, saying it has no basis in law. That came out late last week, right after the Supreme Court's decision, but I haven't seen anything else come out of the Citizenship and Immigration Service. There's a very real risk, of course, for folks who are new applicants or might be new applicants for DACA. The DACA application process has always required revealing your identity, your address, intimate information. And there is always the risk that that information could be used for enforcement purposes. Maybe not immediately down the road. The Trump administration had previously said that if the Supreme Court allowed it to actually rescind the DACA, that it would think of DACA recipients as perfectly suitable targets of enforcement action. So I think as advocates, as lawyers, that requires a very serious conversation with clients who are thinking about initiating a new DACA application. I think for renewals, that decision-making point has passed. But that's a very important sort of ethical dilemma for attorneys who are counseling DACA applicants. Moving beyond DACA and more recently than last week's Supreme Court decision on the 22nd of June, which is I think was Monday, the President Trump issued a presidential proclamation that bars entry of an enormous number or several, I should say, non-immigrant visa categories. Non-immigrant visas are the opposite of immigrant visas, which we often just refer to as lawful permanent residents. So the opposite of folks who have lawful permanent residence. This is people who are allowed to come into the United States temporarily for specific purposes that are outlined in the various visa categories. And the president formally announces that this is his way of trying to help U.S. workers during this pandemic-related difficult economic period in which the United States finds itself. And to do that, the president has barred the entry of 3 different categories of non-immigrant visa holders. H-1B and H-2B non-immigrant visas that generally is folks who have a bachelor's degree, at least a bachelor's degree, so college educated professionals. These are heavily used by STEM fields, STEM workers, science, technology, engineering, and math. So lots of the large technology companies rely on these non-immigrant visa holders. A different category that's also barred is the J non-immigrant visa category, specifically folks who are coming to the United States for internships, for training programs, as teachers, camp counselors, au pairs, and lastly, the L non-immigrant visa category is also included in the banned list. And this is folks who are what we describe as intra-company transfers, so being moved within the same company, perhaps to come open an office in the U.S. or to come have some kind of role in the office, in an office that exists in the United States. It applies to folks who were outside of the United States on June 24th, so yesterday, and who did not have a valid non-immigrant visa. It doesn't actually revoke any non-immigrant visas that have been extended, and does not apply to folks who were here yesterday. Also excludes people who are the who have United States, who are the spouse or the child of a United States citizen. It excludes lawful permanent residents. It excludes anyone who is essential, as I just quote the language, essential to the United States food supply chain, and anyone whose entry is in the national interest. There's some more details about what constitutes national interest in the presidential proclamation, and also folks who have investor visas, EB-5 investor visas. As a starting point, the presidential proclamation is valid, is in effect until December 31st of this year. There's always a possibility that it can be exempted. Seems to be that Canadians are exempted from the presidential proclamation, though I'll allow Ravi, I think, may have better information about that than I do. And it's also important to note that perhaps because it's new, perhaps because it's the Trump administration, we haven't actually seen any agency guidance about how they are actually applying this order that the president issued a few days ago. The State Department has released very limited amount of information, but at the same time, there's the effect that the pandemic has already had on U.S. consulates, U.S. embassies abroad to take into account, which is that most routine visa services have been on hold since going back to March 20th of 2020. There's I haven't seen any of the administration suggest that we can expect a resumption of visa processing as was going on, pre-pandemic. And so the immediate impact of this is likely to be somewhat delayed, at least until we would normally get back to the world in which the State Department is actually adjudicating non-immigrant visas. Of course, yesterday, I'm not hopeful that that's going to happen anytime soon, because just yesterday, the Citizenship and Immigration Services also announced that it is on the verge of furloughing up to 70% of its staff. And it'll decide on or before July 2nd whether it needs to do that. But this is an agency that is primarily funded by fees rather than money that is appropriated by Congress. And so there are various efforts by the Trump administration to limit the number of people who are eligible for visas of all kinds have resulted in fewer applications, which means fewer fees, which means less money to pay staff and to actually run the business of the agency. And so it's actually suffering from an enormous amount of budget shortfall. And I'll just say very quickly, talk about some of the litigation going on with regard to demands for release from the Immigration and Customs Enforcement Agency's prison network due to the risk of COVID-19 infection. As of yesterday, there were let me see, what is this? 2,489 confirmed cases across that have been of people who have been detained by the Immigration and Customs Enforcement Agency during the pandemic. Those confirmed cases come out of a total of 8,858 people who have been tested. So about 28% of people tested have been confirmed positive. That's among the detained population. Among the employees, 45 ICE employees have tested positive, but the agency refuses to disclose how many non-ICE employees, and this is relevant, have tested positive. And this is relevant because most of the agency's prison system is actually operated by private corporations, and most of the staff that actually operate the prison system do not work for the Immigration and Customs Enforcement Agency. They work for companies like CoreCivic and the Geo Group. And so we don't actually have a good sense of how many employees have tested positive. But as Lupe mentioned earlier, has been widespread litigation in federal courts demanding release, and some of that is starting to have some effort, with about 486 people released. So I'll stop there and look forward to questions and to comments.
Thank you very much. Before we start the questions, Ravi, can you weigh in on the Canadians being able to come here, people from Canada, whether it's if they're covered by the ban?
No, they absolutely are not. So that was sort of the initial thinking. But yesterday, ALA, CBP, OFO, the liaison committee received confirmation from CBP headquarters that Canadians entering as H's, L's, J's are exempt from the President's proclamation, and guidance has been already provided to CPB reports on the issue. So that's an ALA bulletin just released, so Canadians definitely exempt.
Great, thank you. And Elba, Maria, Elena, how is Mexico, people coming from Mexico, are you also exempt, or we may not know yet?
We don't have any restrictions for those to Mexico.
Well,
yeah, it's a very friendly government that we have. There's no bans or restrictions.
Thank you. Okay, so just a few words again, if people could use Q&A. We do have a couple of questions. I just want to make a couple comments that whether you're representing people who are primarily businesses or family-based, how important the contacting people, well-being, how are you doing? Perhaps they suddenly want a will. I'm getting some of that, or power of attorney or something, and advise clients to make sure that they have some kind of crisis plan where they have all pertinent documents, information, keys to cars, residence, payroll, someplace where, if necessary, people can access it. So an emergency plan for families and for businesses, highly, highly recommended. So I'm going to, this is from an anonymous attendee. I read this Tuesday a DC Court of Appeals threw out a lower court's decision regarding the possibility of applying expedited removal to people who've been in this country for 2 years, since the Department of Homeland Security has the authority to do so. Can anyone of our, again, if you ask a question, please indicate if you want someone from US, Mexico, or Canada to respond. So can anyone from the US respond about that, please? It may be, I didn't know about this, so it's possible we don't have enough information yet.
Yeah, I think that's a reference to a decision from the DC circuit. It's called I think it's Make the Road New York versus Wolf, versus Chad Wolf, the acting director of DHS. This was an administrative procedure challenge to the what's called the expedited removal policy. So expedited removal is a sort of fast track way of removing people from the United States who have no permission, no authorization to be in the United States. Traditionally, the expedited removal had been applied in a fairly limited fashion, both geographically and temporally, to folks who had been in the United States for less than 2 weeks and who were apprehended within 100 miles of the US-Mexico border. The Trump administration expanded that to the fullest extent possible under the statute, which is 2 years, and anywhere in the United States. Or had tried to, and had been blocked, prevented from doing that by a federal court in Washington, D.C. And then the decision, it came out this week, but I forget when, reverse that, overturn that lower court decision, saying that it was possible for the Secretary of Homeland Security to make this expansion in the way that I think it was she did so at the time.
Thank you very much. And Ravi, there is a question about the temporary migrant workers in Canada.
Not sure what that relates to. I mean, there's certainly a number of farm workers who've been coming from Mexico. There was a bit of an outbreak, despite some rules on the books about paying them, making sure for 2 weeks and 14 days they have to quarantine. The employers have to pay them. There has to be proper accommodations. There were some difficulties at meat processing plants and some farms. So Mexico said, look, we're not going to send people into Canada. And recently, the Mexican and Canadian governments agreed that they would continue to send workers into Canada after the relevant minister indicated they were going to beef up inspections. And I think there were certain farms in particular that were problematic. In fact, when you look at the number of cases of COVID in Ontario, it's mostly concentrated in a particular area where there's a number of farms. So this is actually an issue was an issue for us opening up Ontario in terms of businesses, restaurants, haircuts and stuff. So that could be what you're talking about. Otherwise, I think in the presentation I covered in terms of foreign workers, if you're coming from the States, not so much of an issue. If you're coming from the rest of the world, you need to have that work permit approval in advance. And really, operationally, I didn't quite get to this part. Operationally, although technically you can come if you can get that approval, because they're short staffed at the visa posts, and even though technically you're able to apply for any type of work permit, they're really only prioritizing those who are critical to infrastructure, critical to the food supply, or aiding in the fight against COVID-19 in terms of doctors or researchers.
There was a question that was asked. They said, so Trump is not giving permanent resident visas to people who want to study. I think the question is more, what is the status, I guess, in each country about people who want to go and study, whether it's Mexico, Canada, or the United States? Let's start with Mexico.
Yes. Well, those foreigners entering Mexico with the purpose of study, they will not get a permanent resident card. No matter if they stay in Mexico for 5-6 years studying, you will have to convert your temporary resident status, your temporary student resident status to the temporary resident status, and then you will be able, after 4 years, to obtain a permanent resident card in Mexico. So as a student, you cannot obtain a permanent resident status.
So I think the question was more along the lines of, are the 3 countries even accepting international students right now, the F1 visas? Is Mexico actually accepting international students right now?
Yes, but the problem is that to obtain a student visa, you have to go to the Mexican consulate first with some documents and papers. And at this moment, most Mexican consulates are closed. So there's nothing you can, yeah.
That's a problem. César, professor, are we going to see an influx in international students, or do you think they're part of the ban?
No, in fact, U.S. institutions, colleges and universities have, as Ravi suggested about Canadian institutions, have come to rely quite heavily financially on foreign students, especially foreign graduate students. And one of the realities for the last several years has been a plummeting of applications from students as it's become more difficult and the political environment in the United States has become more tense toward foreigners. So the proclamation that was released this week does not on its face affect students or people who want to come to the United States as students. It does apply to people who want to come on a Jain non-immigrant visa to pursue an internship opportunity. It applies to teachers, of which there are many, especially in secondary and elementary schools that have a foreign language component to them. Spanish being a major, very prominent option. But the fact is, you know, the number of applicants for colleges and university students has been going down for quite some time.
Yes, sadly. Ravi, international students who want to study in Canada?
So you have to be issued your student visa or have a valid study permit or have your student visa issued before March 18. So if you had, then you can come in, you know, particularly if your stuff is here, you've been studying already, you just got caught abroad, but you had issuance prior to March 18, you can come back. But otherwise, in terms of the, you know, the fall, right now, no, which is why they're giving that extra flexibility of allowing students to start studying online. And it will not affect your ability. Up to 50% of the time can be studied online, and it won't affect your ability to get the coveted postgraduate work permit that you get after graduation. Only to some colleges, by the way, not all. Private colleges are a no-no. The public colleges in Canada, which are in part funded by the state, those colleges are the ones that when you graduate, you're able to get an open work permit. And with that open work permit, getting a year of work experience in Canada potentially allows you to get immigration. I say potentially because we're admitting an awful lot of students, and you know, the pie is only so big, and there's a piece of the pie that's for those particular students that, you know, if you worked in Canada and then you graduate and then you work and then you apply for permanent residence, we're not going to be able to transition all of them to permanent residence, which is not something the government talks about when they are welcoming all these international students.
Thank you. Thank you. Well, we have time for one last question and short answers. So I'm going to ask a representative from each country, where are we going in the wake of COVID-19? Is there light at the end of the tunnel? So I'm going to start with the US because if you could, I mean, just what do you think is going to happen? What's going to happen in December in the US? Where are we going with this? Or we may not know. It may depend on what happens in November. So Guadalupe, César, do you want to just briefly comment on that?
I think where we are going will largely depend on what administration, and what happens with the election in November. A lot of these policies that have been enacted have been because of this current administration. And although like practitioners have been strongly litigating these practices, it's strongly reactionary to everything that comes out of the administration. So
thank you. No, I think it was mentioned by César, the significant delays already in adjudicating people who want to legally become residents or even become United States citizen, and doesn't look good. Elba, Maria, Elena, where are we going in Mexico post COVID-19 when that comes?
Well, I think we will have a lot of bureaucratic challenges. The thing is that the system is currently overflow either by Comar and the National Institute of Immigration. So I think we will have a lot of delays in the dockets, which is going to be a challenge for practitioners and even the clients. I also think it really depends on which segment of the population you're talking about, because yeah, I think it's quite illustrative that Maria Elena and I are talking about the same issue from different perspective, because as she was saying, like the government is very friendly, blah, 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 but it's more like a certain type of people coming to Mexico. And on the other hand, we have, pre-migration is a great term. For people seeking, for people seeking asylum and trying to cross to Mexico in order to be protected. So I think it will we will have a landscape of a lot of delayed dockets. We will also be depending on the use of the force in the south border with Guatemala and Belize in order to keep understanding how the humanitarian action from the Mexican government is going to be deployed. But I don't know, Maria Elena, on the other face of the coin, how does it look like?
Yeah, I know. And I do understand that I mentioned that this is, that we have a friendly immigration law, and this is due to the fact that we deal with corporate immigration. But we will, yes, we will expect some delays. Now you have to take into consideration that they are working right now. So if you're here, if you're listening, just go ahead, go to the National Immigration Institute and do your process.
Thank you. Thank you. And Ravi, where are we going in Canada?
The minister just, well, one of the national papers in Canada just talked about how, you know, as I said, like with the Spanish flu, there was a decline in the number of births. So we are anticipating a decline in the birth rate in Canada. Obviously, there's operational problems. Even though we want to bring in people, we're not able to and meet the targets. So I think that nevertheless, I'm pretty optimistic because I think this government is very committed to immigration, and they see it as a way to facilitate the recovery, the economic recovery. And so I think that, you know, and we're going to pivot. I mean, after this proclamation, Canada is going to pivot even further. We already pivoted with the Trump administration coming into power and the sort of nativist language around that, trying to attract people in Silicon Valley and others with special targeted work permit programs and immigration programs. So we have those on the books now, and you can very easily get into Canada these days using those programs, very high skilled people. So I think we're gonna you know, see in the future with this new tender the government just put out, saying they want to innovate the way immigration processing takes place. They want to do that, I think, in part because they want to make it, you know, it's a bit different from the usual problem where we have so many people who want to immigrate, but we have levels and we have caps on the numbers of people that can come in. So we control the intake, if you will. Now we have the opposite problem. We have, you know, people, there's just an artificial, unfortunate problem where we can't bring in the numbers we want. So we're going to now modernize the system. And I think next year we're going to bring in even more people than was planned for. So I'm actually quite optimistic about the future.
That is great news. I would like to have the same news in the United States. I don't know. Again, I think a lot of it is going to be depending what happens in November. We've had an international audience. I'm getting messages from Mexico, from all over. All think you are fabulous. You are fabulous. I want to thank all of our wonderful panelists, and I want to thank the people who took the time to come in here and listen and learn and ask questions. Very engaged. Again, thank you to Skip Harsh, to Veronica, to people who are assisted in this, and maybe we'll meet again, as they say, and I hope that we will. And again, thank you very much. There'll be a recording on this that will be probably tomorrow or Monday, will be on the YouTube and ABA website. So if you missed something, you want to hear what you said, or hear what I said, or what someone else said, you can turn in. Again, have a great day, and we have to remain positive and continue the good work. Thank you so much. Thank you so much. Be safe.
Thank you. Thank you, everyone.
Thanks, everyone.